Hello, everybody. So good to have you guys here. I'm sorry I'm running a little later than normal. It was movie night. We watched Mary Poppins and we had a really good time. And yes, Philip sang along, as everyone was warned he would. Oh. Hello. Good to have you here. Yes, it was a great time. I am so glad that you guys came out for that. Hi, Brian. Good. I'm so glad you're here. We did. Yes, you are correct. I'm not going to do it now. I'm tempted, but I won't. I don't want to lose subscribers. Everybody would run for the hills. And I guess the next one is going to be Princess Bride, of course. And then Chitty Chitty Bang Bang's on the list. I've never seen that. So that one's a mystery to me. Hi, Linda. So good to see you. Ooh. Oh my gosh. See the magical powers that I have? I did that. I remember that. Oh my goodness. Yeah, we'll have to do that eventually. And Who Framed Roger Rabbit? We got to do that. We've got to. Yeah. Hi, sweetie pie. Glad to have you here. So I have some cute stuff. Brian, are you in our Discord? If not, you should be. I've never seen Dr. Detroit, I'll be honest. But if it's anything like what I've seen in Detroit from streaming, oh boy. I have to close this other computer because every time somebody Discord messages someone, it blue loop, blue loop, blue loop. And Billy's been a little pain in the ruckus tonight, so he is beside me again now, but he very much wants to be laying on the computer or on the keyboard, and he's very mad that I don't want him there. I'm sorry. You guys are just funny. Me, Linda was. Oh, I do love my crew. I love my chat. I love my replay crew. I love my people. You guys are so great. I don't mind when my forehead's on the keyboard, but I'd rather my whole face not be, or I'm going to wake up with a wet keyboard. I'm just saying. I had some drool on my desk the other day. Most days. No, I'm just kidding. remember that, Iris. Yep. Is that anything like the any key? Well, here, let me wake you up with this one.
No, you think I'm stupid? Stand up, stand up. Don't talk when I'm not talking to you. You think I'm stupid? You think I didn't see what you were doing?
Ooh, that's what we've got coming. Yep. I am going to start out with I'm going to start out with the 2 hearings with 1 judge, and the judge is fed up with this guy. I'm hoping I got them in the correct order of appearances, because I'm not 100% sure which one happened first, but I think I got them right. But the judge is just he's all kinds of done. He's done.
Sneezes.
Where is he?
Okay. Even though he's not starting his video when I asked. He's even there.
Read the instructions on the Zoom page.
He has audio now.
All right. We need your video turned on as well.
This is for you,
Upper
Linda.
right-hand part of your screen, little blue box with 3 white dots.
Hello.
There we go. All right, folks, good morning. We are on the record for the 28th Circuit Court for Wexford County, and we're taking up the case of the people of the state of Michigan versus Matthew Johnston. This is file 20-12743-FH. Appearances, please.
Corey Wiggins on behalf of people.
I'm Jeff Pearson. I'm here on behalf of Mr. Johnson.
Mr. Johnson joins us today via Zoom from someplace in the world today. Also here in the court is Lindsay Simmons from the Michigan Department of Corrections. We are here today for a formal hearing on a probation violation. There is a request and summons in the file dated October 6th and filed on October 9th. And is this the one just alleging 1 single count about not making payments?
Yes, Your Honor, that's my understanding.
All right. What are we doing today, Mr. Harrison?
I believe it would be appropriate to conduct a brief hearing, Your Honor.
Okay.
And I would call Agent Simmons at the stand.
Raise your right hand. Ma'am, do you swear or affirm that the information and testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Ma'am, see. By the way, I'm watching a show on Netflix called Bodies, where they find these bodies and they've got a tattoo on the arm, looks just like yours.
Okay.
So I'm gonna be listening today with some very interesting stuff, because you might be the killer.
Okay.
All right, go ahead, Mr. Wiggins.
Could you please state and spell your name for the record?
Lindsay Simmons, LINDSAY-SIMMON.
And are you employed at the Michigan Department of Corrections as a probation parole officer?
I am.
And is your office currently supervising Mr. Matthew Johnston?
We are.
To be fair, are you his supervising agent, or are you just covering for that agent today?
I am not his supervising agent. Agent Sean Benatmal is.
Okay. Are you aware of whether or not Mr. Johnston, as part of his probation, was required to pay court fines and court costs?
That is correct.
Do you know what those total costs were?
$1,098.
And to date, are you aware of whether or not any payments have been made towards those fines and costs?
It is my understanding that he has not made any payments.
All right. And are you aware of whether or not Agent Benatmal and Mr. Johnston had any conversations about Mr. Johnson having employment? during his term of probation.
Objection, hearsay. I know the stance of the
Overruled.
court.
Go ahead and continue.
In my review of the notes, from Agent Van Appel's notes, yes, he did instruct Mr. Johnston to make payments.
Are you aware whether or not he was employed?
Yes, and specifically, in May, he reported he was working as a roofer. In June, he was working with Hammer Construction. In July, he was working as a drywaller. In September, he reported he was working as a subcontractor, earning $17 to $20 per hour.
And that was, those dates you gave us, that was this year,
Correct, 2023,
and those are coming from Agent Van Appel's notes?
correct.
Are you aware of whether or not there was any conversation about him needing to pay?
Yes. Per the notes, Mr. Agent Van Appel did instruct him that he needed to make payments on court costs.
Do you know when that was?
I want to say it was specifically in September was the most recent one that I had reviewed. That was just prior to the show cause being filed on October 6th.
And I know I asked the question, I'll ask it a little bit differently. Since September, that last conversation, are you aware whether any payments have been made?
I do not believe that any payments have been made, no.
And to your knowledge, have you seen Mr. Johnston before?
I have,
Do you see him today?
I do. He's on the Zoom video screen.
All right. Thank you. I have no further questions.
Mr. Harrison.
I assume from your answer to that last question that you are firmly convinced that it's the same Matthew Robert Johnston that is your probationer?
I am convinced that is Matthew Robert Johnston, but he is not my probationer.
I understand your office is probationer. Mr. Van Appel is his agent.
Correct.
Do your records indicate that he was placed on probation in September of 2021?
September, or was it August?
Our records indicate he was placed on 3 years of probation on August 6th of 2021.
August 6th rather than September. My
Yes.
apologies. So that would have been through August 6th of 2024, the
Yes.
3 years to have run.
Yes,
So it hasn't yet completed.
correct.
Okay. And was there any set payment plan for him to make? Or was it your understanding he would have his fines and costs paid by the end of probation?
When someone is sentenced on probation, our system divides the number of years that they were sentenced into the money that they owe. And per their probation conditions, we have a breakdown of if they paid X number of dollars, they could have it paid in full in that amount of time.
Okay.
So his probation orders went over with him. And the total amount, if he would have paid $31 a month, he could theoretically have had that paid in full. And he was aware of that amount.
Is that a stated condition of compliance, or is that just a suggestion to make it easier for him to pay it off?
That's a suggestion.
And then Philip ran out of room in his freezer.
On the probation orders.
So his failure to make the regular payments would not constitute a violation.
When he's instructed by his agent
Okay.
to make payments.
So
Which he-
the violation that you're speaking of is failure to follow the written orders of the agent.
And verbal orders.
Verbal orders,
Yes.
okay. And that's one of the numbered conditions in Mr. Johnson's probation.
Correct.
Okay. Just by any chance, this was arising out of a conviction for operating while intoxicated as a third offense. Is that accurate?
That is correct.
Okay. And the judgment date or the conviction date would match that August 6th of 2021 date as well, would it not?
The conviction date would have been,
It was sometime before that.
the conviction date would have been June 18th of
Okay.
2021.
No,
And do your records indicate whether that was by a jury conviction or by a plea?
I believe that was by a plea
Okay.
based on our records.
That's your understanding? at any
Yes.
rate. Okay, that's fair enough. That's all I can ask you for. Thank you. No further questions.
Your Honor. Yes, okay.
The court will just take
Yes, Philip, you're the funny one. Palmyra's the cute one. You know, that's just how it goes.
judicial notice that the judgment of sentence is dated August 6th of 2021. And toward the bottom, underneath the fines and costs, it says that fines and costs not paid within 56 days of the due
Okay.
date are subject to a 20% late penalty on the amount owed. And then if the person is not able to pay due to financial hardship, they are to contact the court immediately to request a plan. That is also appears on the probation order signed by the judge on August 12th of 2021.
May I cross witness?
You may, thank you.
Ma'am, I'm going to show you what's been marked as People's Exhibit number 1. Do you recognize what this is?
Yes,
And can you tell us what that is?
this is an order of probation for Matthew Johnston.
Does that appear to be an accurate copy of the probation order?
Yes, it does.
Your Honor, I would move permission of People's Exhibit number 1.
Mr. Harrison, any objection?
Without objection, the witness is properly identified.
People's Exhibit 1 is hereby admitted. You may continue.
Ma'am, I'm going to ask you to turn to the second page, and at the very top, or towards the top, is there a monthly amount set ordered by the court to be paid?
Yes,
And what is that amount?
$31 per month,
Okay, and does it indicate when payment is to begin?
starting on September 2021.
And was that order signed by the judge?
It was.
Acknowledged, as Judge Elmore said, by the defendant as well.
Yes, correct.
Thank you. I have no further questions.
Mr. Harrison?
I have no further questions. Thank you.
All right, thank you. May I have People's Exhibit 1? Thank you. I have received People's Exhibit 1. Thank you. You may take your seat. Thank you, ma'am.
No further proofs, Your Honor.
Thank you very much. Mr. Harrison?
I have no proofs today, Your Honor.
Thank you. Mr. Wiggins, any argument?
Thank you, Your Honor. I believe that a probation violation has occurred here for the failure to make payments as ordered by the court and is instructed by the probation officer. Judge Fagerman, during his order, had ordered that there be a monthly payment of $31 a month. That wasn't followed. We do know that for at least part of this period, the defendant was employed, making anywhere between $17 to $20 an hour. And again, no payments were made. So I'd ask the court to find a violation occurs.
Mr. Harrison?
Well, Your Honor, it seems to me there's a couple of things going on here.
Go ahead.
I forgot what I was gonna say.
Hold on.
Were you telling me to go ahead, Your Honor?
Nope, I'm sorry.
Perhaps I should.
Let's take a brief recess to allow Mr. Harrison to dial into Zoom, and we'll put the two of them into a breakout room so that way he may speak with Mr. Johnston, and then we'll allow the defense to continue.
I may, it is somewhat premature at this time, but I'm gonna tee up a request to open proofs.
I figured we'll go ahead.
Thank you, Your Honor.
I'll most likely allow that. Go ahead and take some time, and we'll take a brief recess. Thank you. Mr. Johnson, just stay right there, and Mr. Harrison will go into another room. He'll dial into the Zoom, and then we'll put the two of you into a private breakout room online and allow you to have a conversation with your attorney. So
Okay.
please be. Thank you, sir.
716.
You know better.
Thank you for the opportunity to enter proofs here today, Your Honor.
All right,
We would call. Oh,
It's all right. We're back on the record. The parties present when the court recessed are again present. Mr. Harrison tells me that he would like to reopen proofs and allow Mr. Johnston to make or provide some form of testimony. The court will allow the reopening of proofs. Mr. Johnston, please raise your right hand, sir. Do you swear or affirm that the information and testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, sir?
Yes, I do.
You may lower your hand. Thank you. Mr. Harrison, your witness.
Mr. Johnson, you were present, Johnston, rather, I'm sorry. Were you present when the probation agent testified?
Yes, I was.
Okay. And you heard her say that there was an order that you pay a certain amount each month.
Yeah. Yeah, I heard
Okay.
you say that. I was
Were you aware?
of that. No, I was
Okay.
not. I did sign
Why
a
were you-
wage agreement. And I have
Just let me ask the
since
question,
had
okay, Matt?
2 people tried to come and pay the fine in total. Both times, they either accepted the money and they applied to my fine.
Okay, you mentioned, are you also on probation in Grand Traverse County?
I am only on probation in Grand Traverse County, but through you guys, I had my probation transferred to Grand Traverse County. It is
Okay.
the same case. It is from 2018. It is not 2 cases. since then, and everybody's paperwork is getting pretty hectic. However, every month I have reported to Damon Herman here in Traverse City, I successfully completed my alcohol tether, which was during the time in question here I was on alcohol tether. It was strapped to my leg. I was at work in a Myers deli, and my Damon Herman called me to report to his office immediately.
Okay, let's slow down a minute, okay?
I took a breathalyzer test that day in question and signed a paper. So he has it there in Grand Traverse. So
Is
I
it your
really
testimony that you have been reporting regularly to the Mr. Herman in Traverse City?
absolutely every month without fail or violation. And I wasn't trying to make it a conflict at all. I just wanted this fine to be attached to apply it to my credit or something, get it paid when I do my taxes. Either way, I'd rather pay it in full. I've been doing construction, demolition, everything, landscaping, building houses.
Don't you hate when two guys show up to put money on your fines and it just doesn't get applied to your account? Happens to me all the time. People just show up to pay my stuff and never applies to my account, but I know they showed up.
Being successful, saving people's lives, basically helping people get the treatment, the help they need. I worked all the way through COVID. I worked for Ohana. I completed Harbor Hall, Petoskey treatment. While I've been on this probation, before I actually went and did my jail when I was still, and then I went and did my time.
It's all
started.
right. I've already stopped paying attention. There's no question. This is just a narrative. This is not an opportunity. Mr. Johnson, this is not an opportunity for you to ramble. This is how it works in the court.
I've had two people to try come in to pay this, Your Honor. I've tried to come in and pay this in person, and they did not accept the money in Traverse City because I signed a wage garnishment with you guys when I transferred my probation. The only thing here is I just need to come and pay you guys. I can pay you today. I can go into the clerk. I have $60 on me today. I can make a payment.
Time out. We're going to take a brief recess. Mr. Harrison's going to talk to his client, get his client to behave, or I'll lock him up for contempt. Stop talking.
Okay.
Let me ask.
Oh my gosh, I missed that when I was editing. I love this judge. I've already quit listening. And then he just gets up and walks off the bench while the guy is talking because the guy won't shut up. The judge just completely left the bench because the dude wouldn't shut up. If that is not the biggest FU I have ever seen from a judge, I loved that. That was a moment.
The questions, Matt. You're talking over me and you're talking over the judge. It's impossible to pay attention on Zoom, okay? When two people are talking at once. I want to ask you a couple of questions and try to answer them as succinctly as possible, with as few words as possible, okay?
Sure.
Okay. I'll try to follow up as appropriate. I think we can proceed now.
We are ready. Thanks. All right.
Thank you. You may be seated, sir. We are back on the record for the 28th Circuit Court, and we're recalling the case of People versus Matthew Johnston. We are going to conduct this as a hearing, which is what it is. That means the attorney asks the defendant questions. The defendant answers the question that was asked. The defendant does not get to make a speech. The defendant does not get to negotiate with the court and make offers on how to resolve this. He will answer the questions asked. If he starts rambling again, I'll get up and we'll take another break. Mr. Harrison, we're turning back to the defense. You may continue.
Thank you, Your Honor. Mr. Johnston, did you meet with an agent named Sean Van Atmel in September?
I believe, September. I believe he
Or
met with,
ever?
yes, I've met with Sean, yes. I have met with Sean. My probation officer, Damon, told me Sean was, the probation officer in Wexford that was
Not usually.
overseeing my
Okay.
stuff, and he was the supervisor, that Damon was the supervisor of my
Okay,
probation.
I understand that, but you said you met with Mr. Van Atmel in September, correct? Or thereabouts. If you don't recall the date, that's fine. Is that correct?
I don't believe I met with him. I believe I spoke with him.
Okay. You spoke with him perhaps on the telephone?
Yes,
Do you recall Mr. Van Atmel instructing you to make payments on your fines and costs in this case?
no,
I have a feeling this guy knows everything about nothing.
I do not. I
Okay.
recall my probation officer, Damon Herman, telling me to
Okay,
make,
we've talked about that. But my question is specific to Mr. Van Atmel. Do you remember him telling you that you have to make payments on this $1,098 that's owed?
last week at my court hearing, yes, I do.
Your arraignment on this matter, you recall that? Is that what you're talking
Yes.
about?
Yes, that's
Okay.
when I recall Sean saying to arrange payments, and Yep.
Okay. But you were previously unaware that there was a monthly amount that you were obligated to pay. Is that correct?
correct.
Okay. Thank you. I have no further proofs, Your Honor.
Mr. Wiggins,
It's a short leash.
thank you. All right, argument, Mr. Wiggins, we'll reopen it.
I'll rest out, rely on my last minute.
Mr. Harrison?
Well, Your Honor, it seems to me there's genuine confusion on the part of Mr. Johnston with regard to who his actual probation agent is. I'm not sure why. I don't know, and I didn't hear any testimony, so I apologize as to whether his probation was formally transferred to Grand Traverse or if he's simply confused about there being two cases instead of one. I do know in the past, Mr. Johnston has maintained that he is not the person who committed this crime in Wexford County. I suppose at
What was
least,
that?
pardon me?
Repeat that last part?
He has maintained that he is not the person that committed this crime in Wexford County. And I don't know why that is, and I was not his counsel in the first one. But it seems to me he's genuinely confused about a couple of things here, Your Honor. Thank you.
I don't know how I'm supposed to respond to that last comment. There's been absolutely no proof that this is not the Mr. Johnston, and we've had multiple weeks to take care of that question. The court therefore assumes this is the Matthew Johnston who somehow even acknowledges that his probation was transferred. For his probation to have been transferred, he would have to have been on probation for this county, which means he would have to be the Matthew Johnston. I'm just absolutely lost. I don't think Mr. Johnston's confused. I think Mr. Johnston's confusing everyone. But I have a piece of paper here that, by the way, the court takes judicial notice because it's in the file, and the copy that's been provided by the prosecutor, People's Exhibit number 1, was admitted without objection, which says Mr. Johnston on August 28th, 2021, signed a piece of paper that says and ordered him to pay $31 a month toward his fines and costs. And the fines and costs and fees now
$31 a month. That's what his big beef is over right now. That's what Mr. Johnson is fighting. Is $31 a month towards his fees.
not paid within 56 days of the date owed or any installment payment date are subject to a 20% late fee. The court will assert the 20% late fee.
And I will say this, I know this from the courts. If you cannot make your payment, rather than dancing around the bush and making up excuses about two guys showing up to make the payment and it not going on your account. And, rather than fiddling around with it, if you just call the court and say, I'm struggling this month, I can't come. I don't even have the $31 to put on my account. They'll work with you. Sometimes they'll even lower the payment amount. If you don't BS them, they are your friend. And you need to look at them like that when they're the ones that choose whether you are in custody or calling from your vehicle.
And Mr. Johnston's fines and costs have just gone up by 20%. Now, the next question here is, what does the court do with the defendant? I find him guilty of violating his terms or conditions of probation as alleged on the request and summons. Now we turn to what does the court do with the sentence? So I've already started to talk about adding the 20%, which the court will do. But let's see if we have any other argument. Ms. Simmons, do you have a recommendation?
Initial thought, he made a statement that he's able to pay.
Yeah, it's clear he can pay. It's clear he can pay.
So my thought is that he would need to make a payment by, say, 4 o'clock today, and if not,
See, here's the problem.
jail time.
Yep, and here's the problem with that position. And this is where he needs to be advised of what's going on. I cannot, nor will I, barter. In other words, I can't say make a payment or you go to jail. I can't do it. He's already missed the opportunity. He hasn't made the payment. This court will no longer. Stop talking, Mr. Johnson, because you don't do yourselves any favors. So the answer to that comment is I can't. He still owes the payment.
Right.
The question here is do I lock him up? Let's just be fair. The question is do I put him in jail for 15 days? Go ahead, man.
Yes, please.
There we go. Mr. Wiggins?
I would request that as well.
Mr. Harrison?
Well, obviously, I'm gonna argue against that, Your Honor. The only way he's gonna be able to make payment on this is if he's working, and he can't do that while he's in jail.
He's had the opportunity to work for 3 years.
I've been
Mr.
trying
Johnson?
to pay. Yes,
Mr.
sir.
Johnson, hold on. You now have the right to make a statement before the court issues a sentence. Is there
Okay.
anything you wish to say, sir?
Yes, there is, Your Honor.
Okay, go ahead.
I've been reporting like normal to my officer, Damon Herman. I'm at work right now. I do not like to use the phone video stuff. I don't ever do that. I like to come in person. I go into his office. I've had two of my guys try to go in there and that I've worked for and pay my fine off completely, and they wouldn't accept the money because I owe it to you guys. So I was trying to figure out how to do it through him by going through Sean with the payment plan to accept the payments through him. I tried to pay this off completely in full twice in the last month. And I have a bunch of people who know that and that are actually working with me. And I've been sober. I've been doing all my good stuff. I've been sticking with my network. I helped my mother's was at home hurt with her hip and knee replacement that whole time. I was out of work that whole time, but I did 3 extra months of my alcohol tether just to show them that I'm not going back to my old ways, and I'm a man of my word, and I'm damn sure would walk into the office and pay today right now if they will accept my money to go against that fine. Literally. This is for a DUI. My probation. I have completed everything I need to do other than pay my reinstatement fee to get my license back. Also, so that I can drive myself, Your Honor, and I haven't been able to like walk there at all. And all my work that I do has been in Traverse City. I work in Traverse City. I've helped other than Buckley, where my mom and my stepdad live. I'm not trying to get over on the court in any mannerism. And I know that Damon Herman, my probation officer here in Traverse City, I know that he knows that. So I am just at a loss for words that he is not here with us today, Your Honor, because he also knows that I'm not trying to do wrong by any means.
All right, thank you. If I owe the power company money, I don't send my spouse to Meyer to pay. In other words, you are sending other people to the wrong place to make a payment. No wonder they won't accept it, because the wrong people are trying to make the payment, allegedly, to the wrong people.
Okay.
It
Where
is.
do they need to go, Your Honor?
That's okay. Let's just stop talking. Mr. Johnson, your opportunity to talk is now concluded. The answer to this question is very, very simple. You owe the court $1,098 plus 20%. And the next question here is what does the court do with you? Do I send you to jail for 15 days? Now, Mr. Harrison has argued that if I put you in jail, then you are not earning the money to pay the bills. Well, you have been earning the money for years and have not paid the bills. I do appreciate that you have done the other things that you're supposed to have done. However, if you are required to do 10 things and you only do 9 of them, you're still guilty of not doing the 10th. And you have had 2 years to pay this bill. It's your responsibility to pay the bill. It's your responsibility to come to the clerk and pay the bill. You have not paid the bill. So,
Your Honor, I was just in there last week and I did get paperwork from the clerk and she gave me $84. The only record that she had for me, Your Honor, was an $84 thing from 2004, and I was trying to write it last week also, Your Honor. I had taken time off work and got a ride down there.
one moment. Did
My
you
mom
come
actually.
did you come to the courthouse in Cadillac?
Yes, I did last week, Your Honor, with my mother.
All right. Now, if you had a bill from 2004 and this case began in 2020 and was resolved in 2021, that tells me you did not go to the clerk for my court. You went to some other court. One moment, just a second. You have a bill, according to the clerk, in district court that you apparently have not paid from 2004. You owe the circuit court, which is in an entirely different part of the building, $1,098. You went to a different court. You went to the wrong place. So you keep doing the wrong thing.
Okay, I will give this guy some credit. It does seem like he has made attempts to pay. It seems like he does not understand the differences between district court and circuit court, between how different charges can be, state or county or whatever. But stop catching charges. I mean, I've said it before, they're not Pokemon. I appreciate that he says he's sober. I appreciate that. I really hope that he's being sincere about that. And no, I don't think that jailing a person over money is the right thing. But for 3 years, to have hearings for 3 years and every time it's the same thing. You haven't paid, you haven't paid, you haven't paid. At some point, you got to say this is enough. And the argument that, that the county doesn't need the money that bad, it's not about the money. It's about, that's your consequence. That's your stay out of jail. That's what you have to do to make it right. That's not even covering what it cost for the police. And, I don't know if there was an accident, but if there was, the EMS and the fire and everybody else that had to be involved because you drove drunk. So I see owing just, $1,000 or under $2,000 as that's a fair price for what he would have cost the county that night. And eventually you got to pay the piper. That is his consequence. So, but do I think it's right to jail him for 15 days? No. 15 days I think is a bit much. I believe sanctions should start on the low end, and if they need to be increased, increase them. If this is the first time they're putting him in jail for this, then start out with a weekend or start out with a few days or something like that. Don't go from 0 to 15 in an instant. But that's just my 2 cents on it.
So now the question that I have is, what sentence do I issue? The court preserves fines and costs. His period of probation is to end when? I think it's 2024.
Correct, Your Honor.
So he had a 36-month period of probation.
August 6th of 2024.
Okay. So now the question is do I lock him up in jail, or do I do something like extend his probation, which, by the way, increases the amount of supervision fees, which means you pay the county more money.
Okay.
So now I have to decide, do I extend your probation or do I lock you up?
I don't
Now,
know.
public policy is not to lock somebody up for failing to pay their fines and costs unless you are able to do so and choose not to do so. It is clear to the court that I have the ability to pay and have chosen not to do so. So, and the court, and I've let this kind of go today, I haven't addressed it. I do not understand why you are not here in the courtroom today. I did not agree to allow you to appear via Zoom. And this is an evidentiary hearing, which I require people to be in court, which means you are in the wrong place yet again. So
I was
the
told to
court-
appear by Zoom, Your Honor.
It's kind
you have
of
an
his
answer
thing,
for
Judge.
everything, and it's to blame everybody else for all your bad choices. And it is tiring to the court. So here we go.
Your Honor, that is not my answer. I blame myself for my fines.
All right, that's all right. So court again preserves fines and costs. The court will order that they are due, and the court will assess the 20% the 20% penalty for failing to pay on time. As for a period of confinement, what days of the week do you work, sir?
Every day I can currently, Your Honor. I am currently recovering my identity and staying in a tent. And I did have my mother bring me there, but typically 5 days a week. But lately it's been hit and miss. We've been running out of people that want to keep going to work, Your Honor, that want to keep working and doing the hard things that we don't want to do, and staying good and clean and sober so that we can keep getting building and construction and stuff done. And it's just been a struggle. Yep. My foreman here, my fellow contractors also, and I agree with you. Also, I am just very frustrated because I have tried to go to several different places to take care of this and completely, and it's just the circuit court clerk, Your Honor, that I need to speak with to pay my fine. Okay, I can actually request one of these guys. I can talk to him and see if I can't get a ride down there and pay it in full within a short period here. Actually, Your Honor, I could talk to one of them when I get off the phone now and ask if they're willing to do that. I had thought that my probation officer Damon would be here with us today to confirm these things.
All right, so it's okay. Again, let me try to regain control of this crazy train. Okay. Mr. Harrison, as I've mentioned, the court has an ethical quandary because it looks like, and the court does not want to look like it is bargaining with the defendant. And if he pays, he doesn't go to jail. If he doesn't.
I love you, Ralph and Cassie Francis. I'm so happy you stopped in. Thank you so much. Sleep sweet and much love.
Doesn't pay, he goes to jail. And I don't like that. Obviously, the objective here is to get the defendant to pay. I've got two things I now see that I can do. The court will adjourn sentencing and set it for sentencing in 1 week. The court will retract its statements that began to set a sentence. Mr. Harrison, I presume you know what you need to talk to your client about doing.
Indeed, Your Honor.
All right, I'm trying to be, if you have any objection to my approach, let me know. Any objection?
None whatsoever, Your Honor. I believe it to be a practical solution.
I'm not trying at all to threaten a person with jail if they don't pay.
Clearly understood.
But because you have used the word confusion, and it's very clear today to the court that Mr. Johnston is greatly confused. We're going to allow you the opportunity to put him in an unconfused state. Mr. Johnson, you'll talk to your client. We'll set the matter for sentencing next week. Thank you. We are adjourned.
Thank you, Your Honor.
So what just happened there, Dolphins, is the judge retracted because the judge started to set a sentence. Like he started to say, you know, I'm putting 20% additional onto your fines, and he was considering whether the guy was going away for 15 days. But the judge said, you know what? I'm going to put all that on hold. And in a week, you come back and we're going to discuss it at that time. And if you find a way to deal with your business between now and the next hearing, then I'm not going to put you in jail. So this guy has a huge opportunity, golden opportunity right now. And I found the second hearing because I love you. And I guess I did get them in the right order, which I'm so proud of myself for. So here we go. On to what happens to Mr. Johnston a week later.
You may. Thank you, Mr.
I'm getting really close to holding you in contempt.
Hello?
A moment. One moment.
Yes, sir. Yes.
Eunice, we are on the record this morning for the 28th Circuit Court for Washford County. I'm calling the case of the people of the state of Michigan versus Matthew Robert Johnston. This is file 20-12743 FH. appearances from council, please.
Good morning, Your Honor. Corey Wiggins on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Johnson.
Mr. Sean Van Ackmal is before the court as well. He is the agent from the Michigan Department of Corrections, here today as the probation officer. Joining us today via Zoom is Mr. Matthew Robert Johnston. Mr. Johnston, can you see and hear the court, sir?
Yes, I can, Your Honor.
One moment.
And why are
If
you
I
on
look
Zoom?
here, I'm sorry, when I look here at the proof of service for the notice of appearance, does say that counsel and defendant must be present. Why is Mr. Johnston not here in person today, Mr. Harrison?
I am not at all certain. I do know that he does not have a driver's license, and this is part of the reason.
That sigh from the poor attorney. I felt that. That was a moment of just utter defeat. Like, that attorney just is broken by this man. I do know. Oh. Oh, I gotta get in my car and drive over to the Wexford Circuit Courtroom and plug that dude back into the wall because his batteries just ran out.
Why Grand Traverse County agreed to accept his courtesy supervision was that was a barrier for him as far as reporting to Wexford County in the past. I don't believe his situation has changed. I don't believe he has full-time employment either. He seems to steadily work, but it's sporadically and mostly for cash. He may not simply have the resources, Your Honor. I'm unaware.
So he just doesn't have the resources to be present. All right. Well, if I recall correctly, the defendant has been found guilty of failing to pay his fines and costs. We conducted a hearing. That hearing was conducted.
I was able to make a payment last night to the proper clerk, finally.
Yeah. Okay. Thank you. That
And
hearing was.
I met with
Stop.
my probation. Oh, okay.
We're not going to do this again, Mr. Johnson. It's really getting irritating. This works very simply. You are not here in the courtroom. You are appearing via Zoom. When one person is talking, no one else is doing any talking. I conduct who's talking by pointing out when you get to speak. It is now my turn to speak. We're here today for a sentencing on the probation violation. If I recall correctly, the defendant again was found guilty of violating his terms or conditions of probation by failing to pay his fines and costs. We also had testimony and evidence demonstrating that the defendant is able to pay his fines and costs because he is employed. So we're now just going to proceed with sentencing. Mr. Van Ackle, your recommendation, sir.
Sentencing guideline range on this case is 10 to 23 months. Serving for OWI clerk home. He did pay $30 for his fines and costs yesterday. He continues to owe $1,287.60. That included on. He has 118 days jail credit. On probation, he has completed scram without issue of violation. He has not completed any community service hours. On 11/8 of 23, he was instructed to obtain a mental health evaluation.
I have both of those copies.
Stop talking, Mr. Johnston. We're done. Mr. Johnston, I'm going to find you in contempt of court. I warned you last time and I warned you today. You're hereby found guilty in contempt. No, don't talk. Why can you not understand the instructions?
I'm having trouble hearing you.
Well, you wouldn't if you showed up today. I'll deal with the contempt in just a moment. Mr. Van Ackle, you may continue without Mr. Johnson speaking. If he speaks again, we will just mute him. Go ahead, Mr. Van Ackle.
So now we're learning that it's not just the fines that the county was worried about. It's not just the money. He didn't get his mental health evaluation when he was ordered to. and he didn't do any of his community service hours in 3 years. And he hasn't even finished speaking yet. But yeah, so it's not just about the money.
On 11/8, he was instructed to obtain a mental health assessment or evaluation. He's not completed that yet. For sentencing on this violation, I would recommend a continuation of probation with the understanding that there would be additional violations if there's no follow through on the mental health assessment or community service or additional failure to pay for fines.
What was the length of probation that he was originally set for?
36 months.
36, okay.
Was projected discharge date, I believe, would be 8/6/24.
So your recommendation is to continue probation as previously set, preserve the fines and costs. I understand the fact that the defendant has not conducted the mental health assessment and has not conducted any community service. You can't necessarily sentence him for those since he hasn't been found guilty of those. But of course, Mr. Johnston can hear that he must comply with that assessment and he must complete his community service. All right. And do you have any recommendation regarding confinement?
No recommendation regarding confinement, Judge. I'd just defer to the court for that.
Thank you.
Again, he does have 118 days credit.
What was his original sentence for days? Is that
118.
Is that what it was, Mr. Williams?
That's what my notes reflect.
All right,
Yeah.
all right, thank you. All right, one moment. Let's go ahead. All right, Mr. Wickett, on behalf of the people, sir.
Thank you, Your Honor. As the court indicated, that you found that he had the ability to pay and hadn't paid. We did set some time for him to pay, and if I recall correctly, from before, he was saying he could pay it all off, and we received a $30 payment. On top of that, he did not follow the court orders to be here today. I specifically remember the court telling him that he had to appear in person. I'm going to request that, along with Mr. Anapol's recommendation, I'm going to request 15 days confinement.
Mr. Harrison.
I would like to put some perspective in play here. The perspective is, yes, it was only a $30 payment. I'm actually happy that he made that payment. Now, it wouldn't have been the dollar amount that he had insisted he could pay, or it certainly wasn't timely based on the violations. However, it represents, at least in my eyes, something that had been lacking up to then, that of recognition that the obligation is owed to this court. So it seems as though we've crossed what is frankly a rather significant hurdle in dealing with this entire situation. I have spoken to the probation agent in Grand Traverse County as well. He too is concerned with perhaps Mr. Johnston's state of mind and supported the recommendation or the requirement that he obtain the mental health screening that was previously discussed. If the court assuredly will recall, there was a great deal of confusion expressed by Mr. Johnston in the initial couple of appearances in this matter. I'm actually encouraged by the fact that at least one of those issues is apparently resolved in his thinking, that he is now aware of and is at least making some, albeit minor, progress toward resolving the payment that had been lacking in the past. It's a standard kind of concern that I have, perhaps amplified more so in this case. Putting him in confinement and taking him away from whatever employment opportunities he has is be terribly counterproductive, not only to his ability to pay, but his sense of obligation in that regard as well. Thank you.
Mr. Johnston, now it is your opportunity to provide a statement. Is there anything you wish to say?
Mr. Johnston, choose your words carefully. They may be your last.
Regarding sentencing, sir.
Just that I'm doing my best to make everything right. And I've met with my probation officer in Traverse City. He's also aware of my attempts to right this issue and to pay it off completely. I was unaware which clerk to contact, Your Honor. Once I got that straight, I made a deal. But other than that, I apologize for any time spent on my behalf with this issue, because I tried to clear this issue up the day I was released out of jail so it wouldn't present itself at all, Your Honor.
I'm not really sure what that means. If you were trying to clear this all up when you were released on jail so there wouldn't be any issues, you would have paid your fines and costs then. You would have known where to pay your fines and costs because it was only 5 blocks away from where you were released from jail. Mr. Johnston, all I've heard here are excuses upon excuses and how it's everyone else's fault other than your own. Now, ironically, there's one thing I don't know if the parties have picked up on. If I give the defendant 15 days, which would be a sentence of 133 days, he has 118 days of credit. What's the one thing he also gets?
Well, the good time would come off of that. He gets that back.
Which means he won't serve any time.
I understand. That's
So
the dilemma.
it's Mr. Johnson, let's be real clear. This court does not buy much of anything you've had to say. Mr. Van Ackmel has highlighted that he can bring, and whether or not he chooses to do so is his own choice, additional probation violations for your failing to comply with your community service obligation and your assessments for mental health. Those are things he can bring. And if he does, the next time the court would be looking at up to 45 days. So I want to give this defendant the additional 15 days. The court sentences the defendant to 133 days of jail. That's the 118 plus 15.
Okay.
The court gives the defendant 118 days of credit. Now, the question here is does he actually turn himself in on that case? How does the jail establish the good conduct time credit? Mr. Van Ackmel?
Would you like me to call the jail and inquire real quick?
Yes, because then if so, I think one way I can take care of this on paper is to then give him that good conduct time credit as well. But I don't know how I do that because he'd actually have 20 days of good conduct time, right? Almost 20.
Or 4 months, thereabouts, yeah.
Right? It'd be 4 months, it'd be a little less than. So I'm really just questioning here what to do with the paperwork. The other, I don't want to call it a white elephant in the room, but the court has found the defendant guilty of contempt. And I can always add some jail for that, which I'm considering, because I've gotten tired of listening to Mr. Johnson interrupting the court. Now, I could always reverse that finding of contempt. I know very well that there's a very strong language within the judges' associations about using contempt power sparingly. And so I might calm down here. I'm sorry, it's not as emotional. I'm trying to figure out how to deal with somebody who keeps interrupting the court. Mr. Wiggins, any input? Because we kind of had a conundrum here, that it's only 15 days.
As well.
I agree, Your Honor.
Typically, it's the jail that assesses the good conduct time and then releases and then adjusts the release time.
Off of the top of my head, it seems that he would have to at least check in order to
Get his
begin
good
serving the sentence and then have the time
Yeah.
accumulated.
Yeah.
Because otherwise, the jail's not going to have a record that he has, because then he would also, theory then would.
It's my thought as well. He has to turn himself in and then an effect would be released within the hour of turning himself in. This is just a bit of a conundrum that I haven't dealt with. I think he has to turn himself in to be able to establish getting his good conduct time
I
credit.
think it's a formality that perhaps the change in the law did not address in any significant way. So
All right.
It makes complete sense, though. It's a paper trail that they have to have made. He has to turn himself in, and that's the only way that the jail can apply the credit that he has sitting there to the time that he's already served. It's no big deal, dude. You'll get right back out. All you have to do is show up to the right jail by the time you're told. And I wish I knew whether or not you do.
Kind of left to fend for
So,
themselves.
yeah. All right, so here's what we're going to do. The court, again, continues with its sentence on the probation violation. The court sentences the defendant, as I've already stated, to the 133 days, and the court grants 118 days of credit. The defendant must turn himself in to the Wexford County Sheriff Department today by 5 p.m. How he
5
does
blocks
that
apart.
is not the concern of the court. The court continues probation as previously set by this court and preserves all fines and costs. While not a part of the sentence, the court reminds the defendant that apparently he may be in violation of his probation or delinquent in completing some terms or conditions of his probation, and he should contact his probation officer. If he has any questions, he should always contact the probation officer here in Wexford County and or his attorney here in Wexford County. Now, as to the contempt issue, the court is not going to sentence the defendant to any period of jail or any fines and costs. I will let the contempt finding stand, but I'm not going to add any penalty. It might seem to be a bit unnecessary. The court will let the contempt finding stand because the court is in charge of the courtroom and must do all it can to respect the dignity of the courtroom. And that's the message being sent by the finding. But based upon all the information I've heard, I don't think I'm going to add any jail to the defendant's sentence. All right. Anything else, Mr. Van Ackle?
No, Your Honor.
Mr. Wiggins?
No, Your Honor.
Mr. Harrison?
No, Your Honor. Thank you for the accommodations you've expressed on behalf of my client.
Mr. Johnston?
Yes,
You have
sir,
the
Your
right.
Honor.
Thank you. You have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However,
do it,
based
dude.
upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney for you, you must turn in a form that will be provided to you through your probation officer and request that within 42 days from today's date. Now, in effect, I understand that you probably won't actually serve any time in jail, but you must report to the Wexford County Jail today by 5 p.m. I anticipate that they will calculate your good conduct time credit. And if you have not lost any good conduct time credit, you should most likely be released again today. I'm acknowledging that this might be a bit of a inconvenience. I'm going to let that stand because I want the message to be sent through that message, that inconvenience, I guess. One last go around. Anything else, Mr. Van Ackle? Anything else, Mr. Wiggins? And Mr. Harrison?
Nothing further, Your Honor. Thank you.
Mr. Johnston, if you do not have yourself turned in by 5 p.m. today, you could expect potentially a bench warrant to be issued. And you could also expect that that would be a violation of court orders, which could itself be a probation violation. Thank you. We are.
Like, dude, come on. Stop lying. It seriously doesn't suit you. Oh, wow. Lawyer Kitty getting mad. I always forget when I'm going to use that clip that I have to remove myself from the screen when the clip starts, because otherwise my little profile picture in the bottom corner will cover up my previous little profile picture in the bottom corner, and y'all won't get to see Kitty slap me because that was the best moment ever. Oh, I love that clip. Oh, thank you for coming out, Laura. I'm so happy you made it, sweetie. It was such a good time with you. We are going to be going a little while longer, so if you want to catch the rest on Replay Crew, I completely understand. And I love all my Replay Crew people. Oh my goodness. Yeah, that guy just didn't get it, did he? And I was so lucky to have gotten both of the hearings. I just couldn't believe it when I was editing and I found both of them together, you know, through the clips. And I was like, oh, I'm zipping them right together. All right. Now we are going to go to, this is so cute. And I'm going to give you a fair warning now. I've not seen a lot of this one. I've removed all the dead space. But I also did not, I went to the part that I knew was good and clipped that out. And then I left the rest of the docket on. So there's another 50 minutes of this that I haven't watched in the beginning that I took off to start at the good part. So there may be more from this hearing coming later, but this was cute.
In the matter of the people of the state of Michigan versus Anthony Devon Price, file number 22-02655, council appearance.
Jeff Roberts on behalf of the people, Your Honor. Jacob Rowling on behalf of Mr. Price.
Okay, Mr. Price, today's the date and the time set for final pretrial in an aggravated assault. Was there an offer on this?
There was not originally, Your Honor. However, I believe Mr. Price has picked up another case which is set for a pretrial this afternoon. And so there was an amended offer made on this case, and that would be for Mr. Price to plead to an added count 2 of assault and battery on this case, and 1 count of assault and battery on the case set for this afternoon, which is 23-03212 SM. People would dismiss count 1 in that case, Your Honor.
Mr. Baptiste, someone you want to talk to?
Oh, no,
Who are you talking to?
I'm talking to my father.
You think I'm stupid?
No, he was talking to me.
No, you think I'm stupid? Stand up, stand up. Don't talk when I'm not talking to you. You think I'm stupid? You think I didn't see what you were doing? You did it more than once. Who are you talking to?
I wasn't talking to anyone.
Who were you motioning?
I was just motioning, waiting.
Who are you motioning to?
I thought Marissa was pretty good, so.
Oh, and you asked her to call you because I saw you.
No,
I saw you do. You think I'm stupid?
No, I don't.
You didn't do this?
I did that.
We have it on recording.
I know, I did that. I was just.
So why are you lying when I asked you who you're talking to?
Because I wasn't trying to.
Okay, don't do that in my courtroom. You don't motion to people who are sitting in jail. You sit quietly and wait for your case to be resolved, which yours was, in your favor. Don't get yourself in trouble while you're sitting in the back of the courtroom, okay?
I'm so sorry.
Thank you. Behave yourself. Okay.
Now I want y'all to watch Marissa. She's the one in the red top. Watch her face for the next little bit, because the guy admitted that he was trying to get Marissa's attention with this. So let's now watch what Marissa really thinks of that.
Do we have witnesses here on this matter?
As of this time, Your Honor, I had not seen the complaining victim in this matter. However, the complaining victim has shown up. I attempted to call her on Friday. I did not have any contact with the complaining victim on Friday. However, she has appeared at every prior court hearing, Your Honor.
Your Honor, later the witnesses.
She appeared at the October 16th final pretrial.
I believe that was the last final pretrial. Yeah. Yes, she did appear for that one. And she did appear at the original pretrial date as well, Your Honor.
Okay, but you can't make contact with her now?
I did not have any contact with her on Friday. I have not had a chance to attempt to make contact with her today, Your Honor.
Okay, my concern is that the final pretrial on October 16th was reset to today because your client, Mr. Raleigh, did not appear timely. And so that's why you reset it. So he got a chance, we're gonna give her a chance. So we'll reset this matter for another final pretrial. And hopefully we can get everybody here.
Your Honor, I don't know if you want to discuss the other matter now, or just set for this afternoon, but
He has another matter this afternoon.
yes,
Yes, it is just set for the pretrial.
we'd be asking to set that for.
That matter will be set for final pretrial as well. We'll set it for the same dates. 4th at 8 a.m. December 4th at 8 a.m. And then what's the offer, Mr. Brodowitz?
As I said, Your Honor, it would be for Mr. Price to plead to an added count two, on file 22-02-655 SM, to plead to an added count two of assault or assault and battery. People would dismiss count one, with also an offer of pleading to count two, I believe it was count two on file 23-03-212 SM. People would dismiss count one on that file, Your Honor.
Okay, and so you've heard the offer, sir, Mr. Price?
Yeah.
Okay, that offer expires at the time of your final pretrial. You understand that? Have any questions? Okay, we'll see you on December 4th at 8 a.m. on both of these files. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set. That would be it for my final pretrial for someone in more satisfied. On the record in the matter of the people of the state of Michigan versus James Williams.
I think I might have accidentally cut out Marissa's laughing with whoever's in the room with her. She was obviously getting ribbed pretty hard about it. And she was laughing at the attempts of the defendant to get her attention. But I think when I cut out all the spaces, I think I accidentally cut out her laughing. I'm sorry, guys. I gotta really quickly take care of a kitty cat and a dog, and I'll be right back.
File number is 19-04381. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of James Williams, who's a
I also have file number 18-05183, which is in warrant status, Mr. Williams, because you failed to pay your fines and costs. States here you owe $1,374 since 2018. Looks like Judge DeLuca, who's now retired, but just so happens to be across the hall today, was the matter you had this case before. You've not made any payments. Why is that? File number 18-05183FY, which is started off as an aggravated stalking, which is a felony matter that you had before, originally for Judge DeLuca, then it was before Judge Ward. And so you pled guilty to adding count two of stalking. You have fines and costs in the amount of $970 that was referred to collections. You've seen the magistrate before this and multiple times. The last time you saw her was in August. She told you that you owed $1,374. You said you had no idea about this. She referred it to collections upon your release. So you were in custody when you spoke to her about it. You were released in August, you still made 0 payments. So now you can't use the excuse that you didn't know anything about it. Now you just have to tell me why you didn't pay.
So the like she explained to you, it was a few years ago, and I didn't know when I got locked up for these warrants. And so once I got locked up for these warrants, I had to come up with money for housing and to get out. I can make a payment today. I have been making other payments like child support that I neglected for a couple of years as well. I've been clearing up my child support. I had to get my housing straight. And I had to bond out of jail as well. So like I said, I
How
can
much you
make a
gotta pay
payment.
today?
I can pay $150 today.
And when you gotta make your next payment.
So would it be a monthly thing? Can I pay 50 a month? And if
You
I pay
absolutely can.
150,
Okay, I'll note that you'll make a payment of $150 today and $50 per month on the 13th of each month, okay?
Yep.
That will keep you out of sitting in jail on money on that file. And then we have here matter set today for final pretrial on domestic violence. Do we have witnesses here?
This time, Your Honor, I believe the people had no contact with the complaining victim in this case, and they have not made their presence known to me in the courthouse today, Your Honor.
Counsel?
The defense would make a motion to dismiss, Your Honor.
Motion to dismiss is granted. The case is dismissed without prejudice. That means the people have the statutory right to reissue the charge against you within the allotted time frame if they make contact with the witness and the witness is ready to proceed within that statutory time frame. Okay, sir?
Yes, ma'am.
We'll get you a copy of your dismissal. Do you have any questions?
Where do I pay the 150?
We're gonna take you right over to the window in just a moment, okay?
Okay.
Thank you. You can have a seat. On the record, in the matter of the people of the state of Michigan versus Tyrone Hooper, file number 23-02102. Mr. Hooper, today's the date and the time that was set for show cause. That's because you owe $200 on this matter. It looks like you pled guilty to count 2, which is driving while license is suspended, but you never paid the fine. You were supposed to pay $50 the first of every month, starting in October, but I see you're in custody. You're muted. Let me see if I can get this unmuted. Joe, let me unmute. It's clear. Can you hear me, sir? Mr. Hooper? He's gone now. They made a payment when for today. How much? 50. We won't call the jail to put him back on because someone made a payment on his behalf today. Mr. Jackson has an interpreter. Who's representing Mr. Jackson?
Noel Jackson.
Yes, Your Honor.
Noel Jackson.
Are you ready to proceed?
I'm sorry.
Are you ready to proceed?
Yes, we are ready.
On the record in the matter of the people of the state of Michigan versus Noel Jackson, file number 23-00617. We need a prosecutor. Just leave the court. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Noel Jackson.
Mr. Jackson, can you hear us?
Yes, ma'am.
Pretty good understanding. Then we have Mr. Abdallah here.
Yes, Your Honor.
Please raise your right hand, Mr. Abdallah. You solemnly swear or affirm that you were interpreting the matter now before the court completely and accurately and not divulge confidential communication, so help you God.
Yes, Your Honor.
Thank you. Today's the date and the time that's set for a pre-trial. Thank you. It's for an operating while intoxicated. And the last court date, he was denied drug court at 55th. So we were adjourning so he could be screened for drug court at 54B. How are we proceeding?
It is just to clarify, it would be sobriety court at 54B, Your Honor, sobriety court at 55th.
Nasema kwamba ni wewe ulikuwa msukumo kwamba 55B kwamba.
And based on conversations with Mr. Lee, I believe Mr. Jackson is eligible for sobriety court, and we have signed the transfer order, Your Honor.
I do have one problem with the order, though. The defendant himself has not signed it. Is it possible that I can get the defendant's permission to sign it on his behalf? Would the court accept that?
54B would accept. I don't have.
Nasema kwamba angalia, hakuna shida, sina shida nayo. Hata itakuwa asking the 54B, what is that for?
54B is the court that he's going to do his sobriety court. He was screened to do a specialty court there, correct? Is that correct, Mr. Jackson?
Yes, I will go there. I was not told to go there, but if I ask to be going there, I'll go there.
No, my question was he screened to do sobriety court?
No, he didn't get a screen on there.
It sounds like you might want to have a conversation with your client and you might want him to sign that paperwork himself.
Yeah.
Do you want me to reset this in person so that we can have an?
No problem.
Okay. November 27th at 9 a.m.
Mwezi wa 11 tarehe.
Jackson, you need to appear in person.
Thank you so much.
Thank you. You're all set.
Tumemaliza.
Nawaza hiyo
He wants to repeat the date. Can I tell him the date?
Yes, November 27th.
Yeah, yes.
I heard that online. Thank you.
All right, thank you. Thank you so
much, Anna.
Have a good
May I
one.
leave?
You may leave. Thank you.
You're welcome.
On the record in the matter of the people of the state of Michigan versus Amber Valencia, file number 23-02241. Where's Mr. Carter? I didn't see him all day. Ms. Valencia, we don't have your attorney here. You have a substitution for Mr. Carter. I'm not sure if Mr. Carter is. Ms. Valencia, we're gonna have to reset your matter because your attorney's not here. 20 at 10. Yeah. Okay, that's enough time. Ms. Valencia, I can't unmute what happened? Can't unmute her. I'm muted for a minute and then it muted back up.
You reach home?
Mr. Jackson, you're free to go.
All right, thank you so much, Anna.
Thank you. You hear me, Ms. Valencia?
Hear you.
Very good. We have to reset your matter because your attorney didn't come.
That's okay, but I was ready. I was gonna go to rehab this week.
Where are you going to rehab?
Glass house.
It says you're supposed to go to rehab. They'll need to notify us. Your attorney should have let us know so that your bond can be amended so you can be transferred there, okay? Thank you. You're all set. On the record in the matter of the people of the state of Michigan versus Lindsay Buffington, file number 20-03146.
Products on behalf of the people.
Assistant Public Defender John Lee on behalf of Lindsay Buffington.
And then Ms. Buffington, I also have the people of the state of Michigan versus Lindsay Buffington, file number 23-02881 SM. This is a matter in which you allegedly received a citation for on or about September 12th, 2023 at approximately 11:37 a.m. the area of 1207 Princeton, City of Lansing, Ingham County, State of Michigan, allegedly having an unlicensed dog. And so that's a misdemeanor with the maximum penalty of 93 days in jail and or $500 in fines. You have the right to be represented by an attorney, and you have the right to have a trial in that matter. You cannot afford to hire an attorney. You can request to have the public defender's office represent you at the expense of the public. Do you understand that?
Yes.
You're scheduled to be present to be arraigned on this matter on October 20th. It says that you failed to appear, so that's why this matter is in warrant status today. I'm arraigning you now to address that warrant. And so did you want to make a request for a public defender on this matter?
Can I just make the payments? I was in the hospital and I had called and they were supposed to set a new date, but I never got a letter in the mail with a new court date.
Okay, well, I just need you to answer my question. Do you want an attorney on it? Because you have an attorney on your other matter. You could likely qualify on this one. And as of right now, there's no payments for you to make because we haven't resolved anything.
Yeah, can I have an attorney, please?
Okay, so I'll note that you are requesting court-appointed counsel. You have the right again to a trial. You have the right to require the prosecution to prove your guilt beyond a reasonable doubt by proving each element of the charge of unlicensed dog beyond a reasonable doubt. You have the right to remain silent at your trial and not have silence be used against you. You have the right to cross-examine any witness that they call against you at trial, and you have the right to call your own witnesses or present evidence at trial that you believe defense to this charge. I'm going to enter a plea of not guilty on your behalf, set your bond in the amount of 100 personal recognizance. You have not yet completed information to be signed an attorney on this matter. The standard offer from the prosecutor on an unlicensed dog is to get the dog license and provide proof and they'll dismiss the case. That's the standard offer. If you don't have the dog anymore, or you have some other reasonable defense, you'll let your attorney know so that you can talk to the prosecutor about that, okay?
Sounds like it kind of works the same way as when you're an unlicensed driver. They would rather you correct the issue than pay a bunch of fines and costs and fees to the court. They would rather you put the money towards actually getting your dog properly licensed than to pay the fee or the fine for the ticket. And I think that is kind of how the courts should do it. You know, I mean, why bog people down with tons of fines and fees and costs and stuff if they can instead correct the problem from ever happening again and show proof that they corrected it? I think that is a much more worthwhile cause for the money to go to. And maybe just charge them like the court costs of like $35 or something like that, you know, the cost of the hearing for the day, but not go with the hundreds of dollars of what the fines are. So I really like how this court does that. They do that with unlicensed drivers as well, suspensions, things like that. If you get your insurance instead of paying the fine, they'll either dramatically reduce it or they'll just dismiss the case altogether. But if you just sit on it and don't do it, or you just sit and make excuses or lie about it, then you're going to get sacked with a whole lot of more fees.
Okay.
Okay, thank you.
We'll get you a pretrial date on that as well in just a moment. And then as it relates to the sentencing on the assault and battery, I do have a report here that was prepared on November 6, 2023. Mr. Lee, you got a copy of that report?
Yes, I did, Your Honor.
Are we making corrections, updates, or deletions?
No corrections, updates, or deletions, Your Honor.
You can make allocution.
Thank you, Your Honor. We would ask the court to consider that Ms. Buffington has fully cooperated in this matter. She pled, she accepted responsibility. Even the pre-sentence investigation report notes that she showed contrition, accepted responsibility for these acts, which is appropriate and expected. She's a mom of 2 young children and has displayed the appropriate level of acceptance of responsibility in this case. She intends to work hard to complete her probation. She understands that her height of status depends on that. The only thing that we would ask the court to consider is perhaps a shorter term of probation. They are recommending 9 months. I think that 6 months would be entirely sufficient for her to complete an anger management class and demonstrate refraining from drugs and alcohol. So we would ask the court to consider a 6-month probation.
What happened to, I just took care of one warrant, but what happened to the matter in Isabella County? Did you have a warrant? Ma'am, do you have a warrant outstanding in Isabella County?
Not that I know of.
Pleasant Grove, animal abandoning cruelty?
Oh, that was supposed to be, they never contacted me about that because it wasn't my dog. My ex was supposed to take care of that.
I just looked, and you might want to confirm and make sure they've taken care of that, because it shows here on our report and on your criminal history that you're in warrant status.
Okay, I will definitely call them and see what's going on with that.
And I took care of the other warrant that you have for our court. Okay.
Ooh,
did your client
not
want to
good.
make a statement before I sentence her?
I'm supposed to do the dropping and everything. It's just gonna be hard for me because I don't have a vehicle and I'm a single mom of 3 kids and a 1-year-old and a 4-month-old. And I just don't want to be like in violation of probation, and I don't have a job to come up with the money to be able to pay for the drops every time. And I don't have anyone to watch my kids to even be able to go drop.
You have a lot of what you're telling me. Your statement was only to let me know what you're not able to do and to be successful on probation. So how would you be a good candidate for probation, ma'am?
I'm gonna try my hardest to do it. I would rather do probation than jail time.
Well, it wasn't just probation. There was a no objection to the Homes Youthful Trainee Act. So that means that you would need to be successful on probation. And if successful, and I grant you sentencing under HIDA, that means that you would not have a conviction on your public record. This will not go on your public record. But that means you have to be able to do what it takes to get it done.
It means the court is doing you a huge, huge favor already. So stop making excuses and do what you have to do, and it'll all go away.
And so this is a matter where you have now a conviction for count of assault and battery. You got to decide if you're going to be successful or not. I can't make that decision for you. I can give you an opportunity, but you're the one who's going to have to decide. Although it may be challenging, I will make it happen. Because guess what could be more challenging? Trying to raise these children with an assault and battery on your public record. That could be more challenging. It could have impact on your ability to get certain places to live. It could have impact on your ability to get jobs in certain places. It could have an impact on your ability to advance your education.
I'm gonna have to make it happen.
That's up to you. You don't have to make it happen. You could go to jail. That's up to you, ma'am. I don't have any control over that. I'm willing to grant it to you because you're eligible for it. And I think it would be meaningful for you and for the betterment of your family and your future for you to do a term of probation with the benefit of HIDA. That's the point of it, is to make sure you don't end up with this on your long-term record, but that's up to you, ma'am.
I want to do the probation.
Okay. And the report that I have, and I've already gone over your prior criminal history at this point, it states that they believe you to be a good candidate for probation and a good candidate for a term of probation under the HYTA Act, and that you would, or you had indicated remorse for the situation and remorse for putting your hands on the young lady. And we don't have the victim here today, do we? Is that correct? And it's recommended that you attend some anger management classes that are offered by Crystal Ray, and that the class may teach you a better way of emotional management and non-physical releases. I think the term of probation under HYTA is appropriate. I will grant your attorney's request for a lesser term than 9 months. We'll do 6 months of probation. While on probation, you have the following conditions. You're not to engage in any assaultive or threatening behavior. You're not to have contact directly or indirectly with an Anastasia Schultz or Shelby Lucas. Do you understand that?
Yes, ma'am.
You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use or possess alcohol or marijuana or other controlled substance that you do not have a valid prescription for. You're not to be at any bars or nightclubs, and you are required to submit to random preliminary breath testing and urinalysis testing, and you are responsible for the cost of that. Do you understand that?
Yes, ma'am.
Okay. You are going to be required to obtain and maintain employment as part of your probation status. Completed the 11th grade. Is that how far you went?
Yes.
Okay. In lieu of employment, because you are a single mom, I'll allow you to provide proof that you are enrolled in completing a GED or high school education in lieu of employment. You need to do one or the other, but you're going to do one or the other. Do you understand that?
Yes, ma'am.
I'm going to order that you complete anger management and provide evidence of that to your probation officer, okay?
Yes, ma'am.
And again, they offer those courses at Crystal Ray. Do you have any questions about your probation status at this time?
Do I call my probation officer or will she call me?
We'll get into that in just a moment, but I'm asking if you have questions about the terms and conditions that I just went over.
No, ma'am.
Okay. So as to fines and costs, there is a $75 crime victim rights fee that per statute I must assess, plus a state minimum cost that per statute I must assess. 6 months of probation, that is a $30 per month oversight fee for each month. So it's $180 for probation oversight fees. Waive discretionary fines and costs. So your total fines and costs is $305. And you'll be advised when you go over my judgment of sentence that you'll make monthly payments on that. To answer your question about whether or not you'll be in contact with them, you're going to actually need to report to them in person within 48 hours.
Okay.
So once you do that, they'll have your correct contact information and they'll get you all set up. Actually, you don't need to report in person. You can report via phone within 48 hours. Make sure they have accurate contact and phone information for you. And then that way, once my judgment of sentence is complete, they will have you sign off that you review and understand the terms. And then lastly, as it relates to the fines and costs, I just told you it's $305, and I recognize you're probably on a fixed budget. What I would prefer that you do to ensure your success is that when your funds are limited, you prioritize doing your random preliminary breath testing, because there's a cost to that, versus making the monthly payments. At the end of your probation, if all I have is that you have complied with all of my orders, but you didn't make the payments, I can address that without penalizing you. I can't address you skipping out on your preliminary breath testing without penalizing you. Lastly, there's an advice of rights and plea information sheet. Let me also note here that I am granting HYTA. I am granting HYTA status. Lastly, there's an advice of rights and probation early discharge. It states you have the right to request early discharge once you've completed half the original term ordered by the judge. Your probation officer may, but is not required to. They could file a notice with the judge once you become eligible. They would send a copy of that notice to the prosecutor's office, and the prosecutor's office has 14 days from receipt of that notice to file any written objections to your early discharge. You can make your own request for early discharge once you become eligible, and you become eligible once you've completed all the required programming. In your case, I said you need to be enrolled in a GED or high school program or working, and that you needed to do anger management. Once you've completed those things, or at least in the process of completing high school, you can request early discharge, but you must not have had any violations within the 90 days prior to that request. Do you understand that?
Yes, ma'am.
You would make your request by completing a MC 512 form, which is the notice regarding eligibility for early discharge. You would tender a copy of your request to the prosecuting attorney's office. They have 14 days to respond to your request. You're also going to turn in a copy of that request to your probation officer, okay? If a hearing is scheduled to address your request for early discharge, you have the right to hire an attorney to represent you. You do not have the right to court-appointed counsel if a hearing is scheduled for that purpose, okay?
Okay.
Do you have any questions about that?
No, ma'am.
Okay. Do you have any questions about your fines and costs or your probationary terms?
No, ma'am.
Additional matters for the record, counsel. Good luck to you, ma'am. You're all set.
Thank you.
On the record, in the matter of the people of the state of Michigan versus Joel Christie, file numbers 23-02362, 2565, and 2691. Council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
And Mr. Christie, state your name, please.
Joel.
And we reset this matter because this is the matter of livestock involving some chickens, and you needed more time to work on bringing things into compliance. Mr. Brodowitz, do we need more time, or is he all set?
Your Honor, at this point, I still have not received any proof of compliance from Mr. Christie. People would ask them that these matters be set for a final pretrial, Your Honor.
Mr. Christie, what's going on?
My battery on my phone's dead, so I couldn't show him pictures of my progress.
Okay.
Was gonna try to email them to him so that we can, we're wasting the first time.
For final pretrial and jury trial. For final pretrial, November 27th at 8. November 27th at 8 a.m. Jury trial. January 9th. January 9th at 8 a.m. is the date and time set for jury trial. Do you have any questions today?
Your Honor.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
You're all set. We'll get you a copy of your notices.
Let me get the dates just one more time.
November 27th and January 9th. Okay. Garza? No? Person? Is you in person? Present? Shaw, present. On the record, in the matter of the people of the state of Michigan versus Marissa Carberry, file number 20-01754, council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
Jacob Rowley on behalf.
I've been waiting for this one. This is the one that at the beginning, the guy was trying to get her attention. So I'm just dying to know what she's there for.
Ms. Carberry.
Okay, Ms. Carberry, if you can hear us, correct? Like she might be frozen.
That's not Ms. Carberry. Ms. Carberry was on Zoom from home.
No, I know she's on there. She's frozen though.
Oh,
that's why she won't pop up. Okay, Ms. Carberry, can you hear us?
Yes.
Thank you. Okay, and then today was the date and the time that was scheduled for a pretrial on operating while intoxicated. Second, I think she was going to be screened for sobriety court. And then for the record, Ms. Carberry, there was a Mr. Baptiste in the courtroom. He thought you were attractive, okay?
I don't get my boyfriends from court.
That's a good policy to have. Nonetheless, did she get screened?
Your Honor, after further consideration, Ms. Carberry has declined to participate in that court. She has accepted a plea offer.
What's the offer, Mr. Brodowitz?
The offer would be, and I believe this is how it would be to plead to an added count 2 of operating while intoxicated, first offense. Notice, Your Honor, with restitution for MSUPD for their OWI request, and then people would dismiss count 1, the operating while intoxicated, second offense.
Oh, Ms. Carberry, you want to accept an offer to plead guilty to operating while intoxicated, first offense?
Yes, please.
Please the right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I do.
Thank you. You can put your hand down. Okay. You have the right in this matter to proceed to a trial, and you have the right to a jury trial. At the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yes.
You have the right to have the prosecutor prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to cross-examine or question any of the witnesses they intend to call against you at trial. And you have the right to call your own witnesses or present evidence at trial that you believe further defense to the charge. You have the right to remain silent and not have silence at your trial be used against you. Do you understand that?
Yes.
And you want to give up all of those rights today in order to plead guilty to operating while intoxicated?
Yes.
Anybody making any promises to you in exchange for a guilty plea?
No.
Anybody make any threats to you to get you to waive your rights and plead guilty?
No.
Are you currently on probation, on parole, or have any other matters pending?
No.
You understand that a guilty plea can result in a conviction that you may need to report to your current employer?
Yes.
A guilty plea can result in a conviction that you also may need to report on a future job application. You understand that?
Yes.
Guilty plea could have impact on travel or immigration status that you may seek in the future. So you may want to go to Canada and they could deny you entry because of this conviction. You understand that?
I understand.
I know it's Michigan, and the jail does say Ingham Jail, so that's as much as I am aware.
As to operating while intoxicated, first offense, how are you pleading?
Guilty.
Are you pleading guilty because you believe you're guilty?
Yes.
Factual basis, please.
Your Honor, Ms. Carberry, going back to the early morning hours of March 13th, 2020, were you operating a vehicle on a public road, being Michigan Avenue in the city of Lansing?
Yes.
Well, she doesn't get her boyfriends from jail, but I mean, maybe she'll get them from my chat.
You had some alcohol drinks before operating that vehicle.
Yes.
Do you recall what you had to drink?
Angry Orchard.
And is that an alcoholic beverage?
Yes.
Were you stopped by police on Michigan Avenue?
Yes.
Did the police tell you why they were stopping you?
Yes.
What was the reason for the stop?
I was speeding.
And did the police ask you to do some field sobriety tests at the stop?
Yeah.
And after those tests, did the police determine that they have reason to take you into custody on suspicion of operating while intoxicated?
Yes.
I love you,
Did you then
Jenny
submit to a
Green.
chemical test?
Like a breathalyzer?
I believe it would have been a data master. It is a breath test, but it's different from breathalyzer. Yes.
Yes.
You acknowledge that the result of that test was above 0.08 alcohol
Yes.
level, and you have no reason to dispute that result. Is that correct?
No. Correct.
Any questions from you, Mr. Brodowitz?
People are satisfied with the factual basis.
Court is also satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. Matter is set for sentencing January 9th at 9 o'clock in the morning. You need to report to our probation department no later than Wednesday of this week at 10:30. They'll get you scheduled for a pre-sentence interview, okay?
Okay.
If you've not already undergone a alcohol and substance abuse assessment, you are being ordered to undergo one so that I know how to best sentence you, okay?
Okay.
Do you have any questions at this time?
No, ma'am.
Any additional matters for the record, counsel?
Nothing from the.
All set for today, ma'am. Thank you.
Thank you.
On the record in the matter of the people of the state of Michigan versus Corey Goss, file number 20-03.
Fun fact, you are about 7 hours from me. It would take me 7 hours plus bathroom breaks and food breaks and more bathroom breaks to come see you. My goodness.
656, counsel appearance.
Jeff Braddock on behalf of the people, Your Honor.
Morning, Your Honor. John Abbott representing Corey Goss, who's standing to my right.
Okay, we were setting this out for a review because he's waiting to be placed in residential treatment. Is that correct?
He is continuing to wait.
Well, we have no update as to how long that's going to take.
No, we have no update as to how long that will take. And based on my experience in other cases similarly situated, it may be a long, long time.
Okay, we do have an update in our file. It says that he was ordered, the order was for May 2023. There's a 6-month waiting period right now for a bed, which wouldn't that put us at today? So it should be coming anytime then.
Anytime now.
So we're getting close.
However, I have an alternative possibility that I'd ask the court to consider. His mother, who lives in Alabama, has access to an excellent care facility there and a program that he could participate in. Currently, he's participating, I think he counsels once a month at CMH and he gets an injection every 3 months. His father's here in the court with him and he provides support to Corey. His mother, however, lives in Wetumpka, Alabama. Where is that?
What's the next two?
And I would ask the court to consider modifying his bond so that he could go to his mother's house in Wetumpka, Alabama, participate in the mental health treatment there that's available immediately.
What's the treatment there? We don't have anything? We don't have any names or
I
programs?
don't have a name, Your Honor.
Do we have any assurance that he's already been accepted to do that there?
I have no assurance of that.
Well, we demand reasonable assurance.
Okay. Your Honor, I should also mention to the court that if we go to trial on this, my expectation that the court will find out that he was given some credit cards by a couple of young ladies and said, here, go ahead, use these. He did use them. He bought a chicken dinner and 2 cans of beer and a pack of Newports. That's a crime document.
Yeah, I don't have any reason to dispute that. And it's from 2021, but the prosecutor is holding fast on this.
If I get more details on the Wetumpka, Alabama mental health situation, can I approach the court?
Please do.
Between now and the next hearing?
I'm just gonna reset it 1 week and that'll give you to provide opportunity to provide us additional information and provide that to the prosecutor's office and the prosecutor's office to review this file and see if it's in the interest of justice to continue to hold it over.
Thank you very much, Your Honor.
November 20th at 10:30. The 20th at 10:30. Do you have any questions at this time, sir?
No.
Any, well, since your father's here, do you have any questions, sir? Additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense.
You're all set.
2.5 to 3
Matter
hours.
of the people of the state of Michigan versus Crystal Drews, file number 23-03185, counsel appearance.
Jeff Braddock on behalf of the people, Your Honor. Jacob Rowley on behalf of Ms. Drews.
Ms. Drews is present. You can hear us, Ms. Drews. Today was the date and the time that was set for a pre-trial and an attempt police officer assault, resist, and obstruct and a trespass. How are we proceeding on this?
At this time, Your Honor, people have made an offer for Ms. Drews to count 2 of trespass, dismiss count 1. With that, I would leave it to the defense, Your Honor.
At this time, we would ask that this matter be set for a final pre-trial matters we need to discuss with you.
I'll set the matter for final pre-trial. I will not require witnesses to appear. December 4th at 8 a.m. December 4th at 8 a.m. is the final pre-trial. Pre-trial, February 6th at 8 a.m. February 6th at 8 a.m. is the jury trial. Do you have any questions today, Ms. Drews?
What are we doing the jury trial?
Excuse me? You said what?
No, I don't have any questions.
Okay.
Thank you.
She walked that one back real quick.
No problem. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
You're all set, ma'am.
Thank you.
The matter of the people of the state of Michigan versus Jessica Rose Hodge, file number 23-02886 and 887. Counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Riley on behalf of Ms. Hodge.
Today was the date and the time that was set for trials on dog backs and license cases.
At this time, Your Honor, the people would, I do not believe we can appearance on this, but the people would extend an offer that if Ms. Hodge would provide compliance, people would dismiss both tickets, Your Honor, both counts on the ticket, Your Honor.
And we'd be requesting another pretrial date so that we can see about that compliance. In the meantime, I wonder if I could get a good phone number from Ms. Hodge.
Ms. Hodge, this is your number ending in 5125?
Yes.
Your attorney is trying to get in contact with you, okay? If you don't hear from him by today, you call him tomorrow, okay?
Sounds perfect.
We're gonna reset this matter. The offer from the prosecutor, which is standard on these matters, is that you bring proper identification for the dog licensing and they'll dismiss this, okay?
Yeah, I was trying to wait for a little mini break to pop in there and say that she looks really cute. I mean, not when I've paused it. No, that doesn't look so cute. But she does. She looks so young and cute, and I do like her hair. And she's there just on a dog violation, and they're doing the same thing. Take care of it, and we'll dismiss it. And hi, Checks and Cherries. I'm so glad you made it tonight.
Perfect. Thank you.
Ooh,
December 4th at 10. You're all set for today, ma'am.
Thank you.
No problem. Okay, let's see. I see a person identified as Meredith Clark.
That's me.
You have a case number?
I don't. I'm here for John Warfield.
Is that your witness or something?
Yes, there was an offer, but I did not have contact with Ms. Clark, but there was an offer extended. Your Honor.
No, I just asked you, was that your witness?
Yes, that is the complaining victim on that case, Your Honor. I could just speak with her briefly.
Okay, well, hang tight. When the prosecutor gets a moment, I'll put him in a meeting room with you. Okay, Ms. Clark? No problem. Okay. On the record in the matter of the people of the state of Michigan versus Gabriel Pruden, file number 23-02370. Appearance, please.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Gabriel Pruden.
No, Mr. Pruden, we reset this matter for pretrial today because there was a supplemental discovery request that had not yet been satisfied in October. How did you get that request?
We have not yet received the body worn camera.
I do have an update on that request, Your Honor.
Yes.
I checked our file this morning. I had not received, I know our discovery department had sent that out. I had not received any update from our discovery department, so I checked our file. According to our discovery department, they did receive a response from Ingham County Animal Control. There is no body worn camera on this matter, Your Honor.
With that understanding, how do you want to proceed?
With that understanding, Your Honor, we would ask for an adjournment. This is a case that involves two co-defendants that are represented by two different counsels. Our hope is that we could find some sort of a global resolution, perhaps with one more adjournment, given the fact that we now know the limitations of the evidence. I can work with Mr. Yang and the prosecutor, and we can come back to the court with a resolution.
On the record in the matter of the people of the state of Michigan versus Jordan Purvis, file number 23-02371. Can I have your appearance for the record, Mr. Yang?
Good morning, Your Honor. Joseph Yang on behalf of Mr. Jordan Purvis. We're both joining via Zoom.
Okay, and so this matter was the co-defendant matter, and my understanding is that there, on this matter, was a FOIA request that was denied by Ingham County Animal Control. Was that for body worn camera, Mr. Yang, or
Yes,
something
Your Honor.
else?
So body worn camera was one of them. There was an additional request, but I don't think that's dispositive of this issue. It was a copy of the complaint to Ingham County Animal Control, but as counsel pointed out earlier, we will try to figure out a resolution now that we understand there's no body worn camera.
It's pink.
Okay, sounds good. So I'm gonna reset both these matters for pretrial. December 4th and 10. Did 10 work for you, Mr. Yang?
Yes, Your Honor, that does work for me.
Okay, December 4th at 10 is the date that we are rescheduling these matters for. Any additional matters for the record on both files?
Nothing from the people, Your Honor.
Nothing for Mr.
Nothing for half of Mr. Purvis.
Thank you. You're both all set. Get you a
Thank you,
copy of your notice, Mr. Prudence, since you're in person. On the record, in the matter of the people of the state of Michigan versus John David Warfield, file number 23-03187, counsel appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of John David Warfield.
It was the date and time set for pretrial on one count of domestic violence. Was there an offer?
There was an initial offer, Your Honor, and that would be for Mr. Warfield to plead to an added count 2 of disorderly jostling. However, that was without having any contact with the victim, as the victim has appeared here today. I would ask the court for a brief adjournment so that I may consult with the victim. That may change the offer that we are extending at this time, Your Honor.
The offer was already extended?
Yes, it was extended on Friday evening.
You've already communicated that offer
Yes.
to your client?
I have communicated that offer.
Did he accept the offer?
Yes.
I know you know basic contract. You can't withdraw the offer because you didn't get contact with your. You can explain why the offer is what it is now, but you can't withdraw it if he wants to accept it. He still wants to accept the offer?
Yes, he does.
Mr. Warfield, the offer was for the people to amend the, or of this to an added count of disorderly jostling. You want to accept that offer?
Yes, Your Honor.
Please raise your right hand. Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Oh my gosh. You can see the look of relief on his face, and you could see the look of disgust on her face before she aimed her camera at the ceiling, because I bet she's having a little bit of an emotional breakdown at this moment. She's the victim of whatever it was that happened. And she came on this call to tell her side, and the prosecutor had never gotten a hold of her. There was already an offer given. He accepted it, and the judge just said, sorry, you can't change the offer. It's basically a contract at that point. Just because you didn't do your job and talk to the witness or the victim, you can't take the offer off the table now. My goodness. I feel bad for that victim. I don't even know what happened yet. I don't even know what the charges were, but they got amended down. And like I said, I mean, look at that little grin on his face at the moment. Like, he knows he just got lucky. And she feels like whatever he's going to get right now is not going to be enough. She's probably screaming mad right now. And depending on what the charges are, I don't know that I would feel any differently in her position.
Yes.
Okay, this matter, sir, you have the right to proceed to a trial, and you have the right to jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yeah.
You have the right to require the prosecution to prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt at a jury trial. You have the right to remain silent at that jury trial and not have silence be used to prove or imply that you're guilty. You have the right to confront and cross-examine in court any other witnesses the prosecution intends to call. You have the right to call your own witnesses at trial or present evidence that you believe further defense to the charge. Do you have any questions about those rights so far?
No.
You're willing to give up each of those rights today in order to enter a guilty plea to disorderly jostling?
Yes, Your Honor.
Anybody threatening you to get you to waive your rights and plead?
What is disorderly jostling? I've never heard of that. Brian Boggs, you said that's your hood. Please explain to me what disorderly jostling is. I mean, is that one of these? Because that's the only thing I can think of.
Guilty to the added count of disorderly jostling.
Yes.
Who threatened you?
Again? Oh, no, I'm
My
sorry. No, someone coughed and I thought I heard you say something else, but no, no one's me.
Okay, my
I
question says,
apologize.
anybody threatening you? I just
Oh,
wanted
no,
to make
no.
sure Mr. Lee didn't put you in a headlock and tell you you got to take this plea.
Oh, no, I apologize. I misheard you.
Okay, very good. And then is anybody promising you anything to get you to want to waive your rights and plead guilty?
No,
Are you currently on probation or on parole?
no.
You understand that a guilty plea could result in a conviction that you may need to report to your employer?
Yes, but I currently do not have one.
Well, you may need to put this conviction on a future job application. Do you understand that?
Yes,
You also can end up with a conviction that might impact where you can travel or immigration status. You understand that?
yes, Your Honor.
As to the adding disorderly jostling, how are you pleading?
Guilty.
Anybody? I'm sorry, you're pleading guilty because you believe you're guilty, correct?
Yes.
Actual basis.
Thank you, Your Honor. Mr. Warfield, on or about October 20th, 2023, were you at the location of 2910 Beau Jardin, apartment 302?
Yes,
And that is in the city of Lansing, county of Ingham, state of Michigan, correct?
correct.
And while you were there, you had an encounter, that is to say, an argument with Meredith Clark, correct?
Correct.
And this argument's out into the hallway?
Yes,
Okay. And there was some grabbing, pushing, shoving type activity?
yes,
Further questions?
Any questions from you, Mr. Barlow? Court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing, and that is on November 13th at 9. I'm sorry, today's November 13th. It's January 9th at 9 a.m. Okay?
Is that in person or will that be Zoom as well? Do you know?
You can appear for your sentencing. However, you do need to report to our probation department in person within the next 48 hours. So you'll have until 11 o'clock on Wednesday to report probation, okay?
Okay, guys. So I did look it up. And so this is the Michigan law regarding jostling, because I had never heard that before. So when someone is in a public place, intentionally crowding and unnecessarily jostles or crowds another person at a time when a third person's hand is in the proximity of such person's pocket or handbag. I mean, that seems mighty specific. And it seems like the intent of that would be more for if someone had the intention of like pickpocketing. It doesn't seem like something that would be used for if someone is crowding. Yeah, if they don't prove the element, that first element, that on or about blank date in the county of blank in a public place, the defendant blank jostled or crowded blank at a time when the third person's hand was in proximity of blank's pocket or handbag. If those are elements of the charge, if they don't put that specific element onto it, then that's a bogus plea. I wonder if he accepts the plea and it goes through like that. I wonder if the victim could file a motion that it wasn't good enough or wasn't enough because they didn't prove every element of the factual basis when doing the plea. Anyways, I wanted to share that with you guys because I'd never heard it. So now we learned something together. Yeah. Yeah. Yeah, that's a new one. So, okay. I love you guys. I just had to say that. I had to throw that in there that I love you all very, very much.
No, she was talking.
No, you think I'm stupid? Stand up.
Sorry.
Okay, is that the number that would be on the blue paper that I got?
Yeah, that's the number, but you got to report in person.
Oh, yes, of course.
Okay, and they'll get you set up for the pre-sentence screening and interview so that I can know how to sentence you best, okay?
Okay.
You have any questions?
Well, now a cheesehead Wisconsinite just taught you something about your state, you Michiganite. Michiganian. What, the clip that I just played? That was the opener, sweetie. Here, let me run it one more time.
Don't talk when I'm not talking to you. You think I'm stupid? You think I didn't see what you were doing?
That was all it was those few seconds. That was the opener. So now when you go back and watch the beginning on Replay Crew and watch, the beginning of when I started her docket, it's the start of her docket. I clipped out like 46 or 56 minutes of the beginning of her docket to get to that clip because I heard her say that and I was like, bam, I gotta have that.
No.
Additional matters for the record, counsel. Thank you. You're all set, sir.
Thank you.
Record in the matter of the people of the state of Michigan versus Matthew Torres. I have file number 23-00818, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Matthew Torres.
Ten o'clock final pre-show. That's just funny hearing. Let's see. We don't have final pre-show slots at 10. Right. Today was the date that was reset for final pre-trial because you had a final pre-trial, Mr. Torres, and you failed to appear. I have a note from the magistrate at your arraignment. It said that you didn't come because you couldn't handle another court hearing.
In front of the court for several years, and the reason why I'm here today is my case with it.
Can't handle another court date, but you have pending matter. That's what you're here for today, disturbing. You have pending criminal matter.
Yeah.
What do you mean you can't handle another court date? You have to take care of your business, don't you?
Yes.
Yeah, you don't get to skip out because you can't handle another court date. You need to appear and take care of your business. Stop tying up court time while you sit at home and hide from it, okay? Do you understand that? Is that a counsel appearance?
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Matthew Torres.
Does this matter continue to trial?
I would leave that to the defense, Your Honor. The people have made 2 offers in this matter. If you would like me to put those on the record, I can.
Yes, please.
Okay. The initial offer was for Mr. Torres to plead as charged to count 1 of, I believe it's disturbing the peace, with a Killebrew agreement for fines and costs. After speaking with the complaining witness at the last date we were set for trial, who are their employees of Friend of the Court, they provided what they would like to see happen. So I extended a second possible offer to the defense, which would be for Mr. Torres to plead to the charge on a delayed sentence, Your Honor. And the condition of that would be that Mr. Torres attend a anger management program, and at the completion of the anger management program, with proof of completion, the people would then dismiss count 1.
You communicated those offers to your client?
No, Your Honor. The second offer is an offer that I just learned of this morning and would like to spend maybe 5 minutes talking with my client about which or if either of those offers.
I would just, for the record, I would apologize to the court for that. Up until recently, Ms. Donnelly from the Public Defender's Office was handling this matter. I relayed that offer to her and then to Mr. Lee this morning as he's taking over the case.
Mr. Torres can have a seat, and when we're available for you to speak to him, you can do that. You have another matter that's already here. Record of the matter, the people of the state of Michigan versus Nicholas King, file numbers 20-03531 and 20-03532.
Jeff Reynolds on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Nicholas King.
And Mr. King, today's the date set in both of these matters for pre-trials on unlicensed dog. Have licenses now, or do we need time to bring them into compliance?
At this time, Your Honor, after conversations with Mr. Lee informed me that he learned this morning that Mr. King apparently no longer has the dogs. The dogs are now with his ex after they've split. And so the people would ask for, and I believe the defense would join me in asking for a brief adjournment so that we can just obtain proof that Mr. King no longer has the dogs, at which time the people would dismiss this for compliance.
December 4th at 10:30. Any questions today?
Oh, Your Honor, would it help if we were to contact my children's mother so that she can confirm that I'm no longer in possession of the dogs since the split?
That's up to the prosecutor. He's the one who's got to hear the evidence or see that evidence. I don't, okay?
Yes, ma'am.
That works for them. That works for me.
Yes, ma'am.
And then he'll make a motion to dismiss if that satisfies it, okay?
May we do that today?
Yeah, I have no
I'm sorry.
problem.
Yes, ma'am.
I have no problem with that, absolutely.
Yes, ma'am.
Okay, you can have a seat there, and then when he's available, he can step out to do that, okay?
Yes, ma'am.
Okay. Off the record on that matter. And Blair Betts is present via Zoom.
Yeah.
Okay, on the record in the matter, the people of the state of Michigan versus Blair Marie Betts, file number 23-02994, counsel.
Jeff Reynolds on behalf of the people, Your Honor.
Jacob Riley on behalf of Ms. Betts.
Today was the date and the time that was set for a pretrial and dog at large. How are we proceeding?
Yes, Your Honor, at this time, I have received an email from Mr. Rowley providing a proof of compliance for his client, Ms. Betts, so the people would move to dismiss this for compliance.
Motion to dismiss is granted. You're all set, ma'am.
Thank you.
It is.
On the
And hi,
record, the matter of the
Patty.
people of the state of Michigan versus David Cheney, file number 23-01459, council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
Jacob Riley on behalf of Mr. Cheney.
Oh, is he in custody?
He is, yes.
Downstairs? Or no?
I put him on.
Oh. Interesting. Here, so we'll reset it.
November 27th at 8.
November 27th at 8. On the record in the matter of the people of the state of Michigan versus Michael DeRose, file number J038155.
Jeff Reynolds on behalf of the people, Your Honor.
Nybert serving on behalf of Mr. DeRose. Mr. DeRose is just there, and I think he just walked away from the camera for a second, Your Honor. Mr. DeRose?
DeRose, can you hear me?
And
Yes.
he's back.
Thank you. Today was the date and the time that was set for a motion to set aside conviction. I have a motion for conviction, date of conviction being April 29, 2004. Mr. Rylitz, did your office receive a copy of that?
Yes, Your Honor, I believe we did. Ms. Nybert did forward or did send to myself, I believe, all of the necessary documentation after we were here last time.
Very good. And we do now have a response from the Office of the Attorney General. The Attorney General's office indicates that they believe the defendant may be eligible to have this conviction set aside under Michigan Compiled Law 780.621. And after the court holds a hearing to determine if he meets the statutory requirements, order could be entered granting that. So, Ms. Nightberg, did you want to address the court, or does Mr. DeRose want to address the court as to what he's been doing since the time of his conviction?
I will, Your Honor. I have interviewed Mr. DeRose. Mr. DeRose is a mechanic through and through. He spent his career doing seats for GM and Oldsmobile, but unfortunately he has been an alcoholic that entire time. He started drinking when he was 13, when his dad died, and then started smoking. He was up to 3 packs a day. Michael didn't have much guidance and therefore didn't finish high school either, Your Honor. Michael went on to have 1 daughter and 2 grandchildren who he loves deeply at this time. He moved to Mount Pleasant in 2008 and 2009 when he met his girlfriend to get away from this trouble that he was in. He's been sober now since 2000 and no longer smokes at all. He feels such so much better inside and out now that he's clean and sober and has all the toxins out of his body. Michael lends his time to his girlfriend's father and helps him mow the lawns and takes care of his rental property as requested by him. Michael loves to work on cars and works on his garden. He tries to grow corn, beans, and peas and potatoes if his dog Ozzy doesn't dig them up before he can. And Your Honor, he tries his best to be the best person that he can be. He tries to give his time to anyone in the community that allows him to do that. He tries to be a friend to the neighbors. He tries to be try to do things for other individuals that ask him to do so. So we're asking that he has this expungement for that time, Your Honor. He would like to get a job to help him with having extra cash to help him do some side stuff that he would like to do with his free time.
Thank you. And your client did not wish to address the court itself today?
No, but his doggy wanted to address the court.
Mr. DeRose, have I said enough for you?
You're muted, sir.
I don't think so. I think he said it was fine, Your Honor.
Okay, very good. I reviewed the application and his prior criminal history, and then hearing the information, ma'am, that you provided on his behalf. I want to applaud him for turning his life around and even addressing those issues or use of substances in his life that aren't even illegal, but just making efforts to try to get his pathway more clear. I think that it's appropriate and according to the law provided to set aside this conviction. I find it to be consistent with the public welfare, so I'll sign and date it for today. Congratulations to you, Mr. DeRose. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No, thank you, Your Honor. Thank you for this time.
Thank you. You're all set.
Thank you, Mr. DeRose. Good luck. See you later.
Back on the record in the matter of the people of the state of Michigan versus Matthew Torres. Mr. Lee, how does your client want to proceed?
Your Honor, my client is going to accept the offer from the prosecuting attorney to plead guilty with a Killebrew to no upfront jail and fines and costs only.
He gave the offer. He said Killebrew with fines and costs. Is it now Killebrew with no upfront jail and fines and costs? Is that what you're saying?
The Killebrew was to just fines and costs, Your Honor.
Okay. Want to accept that offer, sir? You want to accept the offer to plead guilty to disturbing the peace?
Yes, I do.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Have an advice of rights and plea information.
I don't really mind if they want to have their little brotherly love spat in the chat. It does nothing but help the algorithm. Hey guys, hit the like button while you're at it. I don't care who followed you in here.
It has today's date on it, and that's your signature, sir. Read this document.
Yes.
You understand the rights listed here?
Yes.
You want to give up each of these rights today? That means you're going to give up your right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
That's correct.
And you want to waive having them prove you guilty so that you can enter a guilty plea?
Yes, correct.
That means you're giving up your right to remain silent at a trial and not have silence be used against you. You're giving up your right to have the prosecutor prove each element of the charge of disturbing the peace beyond a reasonable doubt at your trial. You're giving up the right to cross-examine any other witnesses that they were going to call. You're giving up the right to call your own witnesses or present evidence at your trial that you believe further a defense to the charge being brought against you. Do you understand that? Is anybody threatening you to get you to waive your rights and enter a guilty plea?
No.
Any promises being made to you in exchange for a guilty plea?
No.
You understand a guilty plea could result in a conviction that you may need to report to your employer. The plea could also result in a conviction that may have impact on travel or immigration status you may be seeking. Are you currently on probation or on parole?
No, I'm not.
No. Killebrew agreement, that's an agreement between you and the prosecutor. I'm not a party to that. You understand that? So that means that when I decide what I'm going to sentence you, if it's different from what you all agreed, I'd let you have an opportunity to withdraw your plea, okay? As to disturbing the peace, how are you pleading? Guilty because you believe you're guilty? Factual basis, counsel.
Torres, on or about October 24th, 2022, Are you at 313 West Kalamazoo Street in Lansing, Michigan?
Yes, I will.
And that's in the county of Hingham, the state of Michigan, correct?
Yes, correct.
And did you, while there, throw a chair or otherwise disturb the peace?
Yes, I did.
Thank you. No further questions.
Any questions from you, Mr. Bartlett?
Nothing from the people, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. Is there an objection to immediate sentencing?
No objection, Your Honor.
No objection. Thank you. Your Honor, Mr. Torres comes before the court contrite, humble, accepting responsibility for his actions. He asks the court's forgiveness and begs the court to understand the incredible stresses and pressures that he has been under in dealing with a friend of the court. Certainly everybody can understand how emotional dealing with ex-spouses and children and custody issues can be. But he does admit that the way he handled it was not appropriate and asks the court to consider his cooperation in sentencing.
Did you find one with the state?
Apologize to the court. It's been pretty emotional. Trying to see myself. I'm probably not gonna see him. I just went down there to file a pay time to play for the down period of time that escalated to an argument. And then I just
Recently was talking to one of my friends who's a family court judge, and I was expressing my sentiment about how emotional family court issues are and how the issues escalate there far quicker than what we deal with when we deal with criminal matters. So I understand the gravity, what was at stake. You're talking about the life or spending time with your child and how those things could trigger emotions that you probably were not at the time equipped to handle. In hindsight, I'm sure you wish you handled it differently. I think you benefit from resources and classes, if necessary, that could help you navigate the system better. You have rights as it relates to being a parent. I recognize you made a statement just now in your allocution or statements to the court that you don't believe you'll see until you're 18. The rules for family law is what's in the best interest of the child. And so you still have rights as it relates to that, whether those rights mean that you can see your child with supervision or without, and how often you will see your child. That's something for the court to make a determination, and you should not give up your quest and your fight to see your child just because of this hindrance. Don't let this stop that.
You don't ever stop fighting for your children, ever, for any reason.
This be a lesson to you. This is not the way to address it. And I don't know if you have an attorney in your other matters. That's for you to decide as to how you want to address your other matters. But those friend of the court issues can be challenging. They can be triggering. You need to do something to make sure that you're still presenting yourself both in courtroom settings and outside of courtroom settings to be a person that can provide stability and support for your son. Sons need their fathers, but he needs to see that you're a good example. And you carrying on and flipping out in the middle of the friend of court doesn't fare well in your favor if what you're trying to show them is that you need to be able to spend time with your child. You understand?
Y'all, he did that in court. At the friend of the court, he picked up and threw a chair because he got upset. I mean, I can understand the emotion behind it, but that is not good. That does not bode well in your favor. You still don't stop trying to get the rights to see your kid, but now you just added on some anger management courses and other stuff to the necessities that they're going to request. Wow.
Understand that, sir? I think that at this point, you suffered enough loss and consequence of being hauled in and out of the court for this matter since the 13th or the 30th of March. And then obviously the consequences that this could have placed on your custody battle. With that being said, I think the Killer Brewer fines and costs is appropriate. Your fine is $100. Over to the criminal traffic window, you can make payment today, and this will resolve this matter. And you won't have any more court matters on this one, but you need to go to all your court dates. You can't blow off your court date because of how stressful it may be. It doesn't help you to go to court on a family matter and get upset and start throwing furniture around. You see that now, sir? Good luck to you. All I have.
Quickly, Your Honor. Just,
Yes.
we don't need to go on. So we were just gonna step out briefly.
Okay,
To
sounds
make
good.
that phone call.
Flores, back on the record in the matter of the people of the state of Michigan versus Angelo Garza. I'm sorry. Who was this man? You get what you needed, or you still need energy?
Yes, Your Honor. The people are satisfied after making the phone call with Mr. King and Mr. Lee present. And so that Mr. King no longer has the dogs in his possession, so the people are moved to dismiss for compliance.
Motion to dismiss on both files. Granted, you're all set.
Thank you all.
You guys look great.
Have a good one. And Garza built it. That's all we have for the morning.
Well, there you have it. We ended it on a high note there of not really. At least the guy got the charges dismissed because he got rid of the dogs that, were the problem for his case. But I feel for that dad. I really do. That one's gonna haunt my dreams tonight. Sometimes you have to look at the people in court, not as necessarily criminals or bad people or anything like that, but as people who are going through something that happened on the worst day of their life, and they reacted badly to it. And sometimes that's all it is. I mean, I've blown up before, never to the point where I've thrown a chair in court, but everybody has their breaking point. But I can understand when you're fighting for your kids how emotionally charged that might be. So anyways, thank you all for coming out. I appreciate it. I even appreciate the 2 kids in the chat that are helping my algorithm. So I hope you all have a wonderful night, and I will see you again very soon. Much love. Be well. Don't throw furniture. I love you all.